Okay, I think we will get started with our program. Thank you for joining us today. My name is Elisa Scally. I'm a partner with Gowling WLG. I'm a member of the Employment, Labor, and Equalities Practice Group. And on behalf of our Employment, Labor, and Equalities Group, I'd like to welcome you to our first webinar series of our 2025, first webinar of our 2025 webinar series. Before we begin our program today, I'd like to acknowledge that because we are all based in different cities and provinces across Canada, we are located in different traditional Indigenous territories, some of which are covered by treaties. I encourage all of us to take a moment to reflect upon and acknowledge the land upon which we are living. If there are Indigenous people attending this webinar, please feel welcome. Now, I would never have imagined that our 2025 webinar series would be kicking off with a discussion on the impact of tariffs on the workplace, but here we are. We have with us here today Wendy Wagner and Chris Andre to guide us through a discussion on the tariffs generally, how they will impact businesses, and specifically the impact on their workforce, and finally, how best to navigate these workforce challenges and mitigate legal risks. Wendy is the head of our international trade group. She also co-leads the cybersecurity and data protection group. Wendy's trade practice consists of providing insight and compliance advice on customs, import and export controls, controlled goods and sanctions, including assisting clients in obtaining permits and navigating the complexities of international trade regulations. Wendy has been instrumental in creating a tariff hub, which is a collection of articles and webinars that provide up-to-date information and guidance on this tariff situation. A link to the tariff hub can be found in the chat. Now, if you've attended our ELA webinars in the past, you will recognize Chris Andre as a familiar face. Chris is a partner and a senior member of our Employment, Labor, and Equalities Practice Group. He provides guidance to employers on all aspects of the employment relationship. I would describe Chris as being very passionate about employment law generally, and particularly passionate about our topic today. He has also contributed informative articles to our tariff hub, so I would really encourage everyone to go over to our tariff hub and review some of the important information that's posted there. Again, the link is in the chat. Now, before we begin our interesting discussion today, there are just a few housekeeping items. The PowerPoint presentation that you will be viewing today will be distributed to all of the attendees following the webinar. This session is being recorded, and the recording will also be shared with you following this webinar. If you have questions, please pose them in the Q&A by clicking the link at the bottom of your screen. We will do our best to answer as many questions as possible throughout the webinar, but please do remember that this presentation is not intended as legal advice. It's intended to be a high-level overview. So please try to keep your questions general. And if you require specific advice, please consult your legal counsel, or of course, feel free to reach out to any of our speakers following the presentation. So now I'd like to turn it over to Wendy.
Hi, everyone, and welcome to the seminar. So this is a very hot topic and one on which we've been getting obviously a lot of inquiries. It changes by the moment, so I'm not going to predict anything in terms of the duration of the tariffs or what might happen in the future because it is completely unpredictable, which is, I think, one of the problems that business is encountering and everyone is really, really struggling with. So the interesting thing is that most of us haven't had to deal a lot with tariffs because we've had a pretty predictable border and a lot of, obviously, a lot of free trade between Canada and the US and other countries with whom we have free trade agreements. So there's not even a really good understanding of what tariffs are and how they work. So we thought it would be helpful for purposes of this session to level set that a bit and provide some information on that. And then we'll turn it over to Chris to talk about the specific impacts on employment. But just so that you can all be tariff experts with a few minutes of background on that, I think that might be helpful for everyone. So What's a tariff? We've heard a lot of information and perhaps misinformation about what tariffs actually are. It's not that complicated. They're essentially a tax that's put on a good when it crosses the border. It's only tariffs are, we get this question a lot. There may be things that happen with trade and services as we go forward through this uncertain environment. But right now, when we're talking about tariffs, those are a tax on physical goods that cross the border. So essentially, you have a product, you order it from the United States, say it is imported into Canada. What will happen is if Canada puts a tariff on that product, then basically the Canada Border Services Agency, which is our customs authority, will collect that tariff, and the tariff is imposed on the value of the good that's declared when it crosses the border. So basically, when you import something into Canada, and everything I say like pretty much goes the other way as well, but when you import into Canada, you have to enter that good with certain documentation. You declare a value for the good, which is normally the cross-border sales price of that good. And then the tariff is applied on top of that value as a percentage basis. So, in my example, I'm ordering a handbag from the US. It costs $100. If we have a 25% tariff on that handbag, then I'm going to be paying an extra $25, which is going to be collected by our customs authorities and basically go into um, our uh, um, revenue stream for Canada. And the same would be true going the other way in the United States. So when we're talking about the US tariffs, the US federal government is going to be collecting those tariffs by the business that pays that tariff or the individual that pays that tariff when the product is entered into the country. So who pays the tariff is another question that comes up quite frequently. Um, the when you import something into a country, as I explained, you have to make a customs declaration around that. And there will be a business, normally a business, that is identified as being the importer of record for that product. And that is the party who actually pays the tariff. So when we're talking about goods coming into Canada and a duty that our government might apply, oftentimes that will be a Canadian company that's acting as the importer of record, and they're going to pay that tariff or have their customs broker pay it on their behalf, but ultimately they're going to be liable for it. But you can also have non-resident importers. So, for example, you might have a US-based company and they import a lot of goods for sale into Canada. So they've registered as a non-resident importer to take care of that importing process. So it's not always entirely certain who will be paying the tariff. It's really the import of record who is oftentimes a resident, but may also be a non-resident. So what happens when the importer of record is liable to pay that duty? Well, a number of different things can happen. What has happened in general is that the price of the product has just gone up, as you can see from our handbag example. So the question becomes, as the party who's liable for actually paying that extra amount or that extra cost, what do you do with that? Oftentimes that's going to be passed on down the value chain. So if I'm the importer of record, say I'm a retail company in Canada, and I import the handbag and I have to pay an extra $25 on the importation of that handbag, I might pass on that cost to the consumer that I'm going to be selling that handbag to. So the cost just got higher for the handbag for that consumer. Or I might say, well, it's a pretty competitive environment for handbags, so I'm not going to be able to pass on all my costs to my consumer because they're just not going to pay an extra, $25, $50 for the handbag. So I'm going to I'm going to cut into my profits and I'm going to absorb some of that extra cost because I know I have to from a competitive perspective. As that importer of record of that handbag, I might actually say to my vendor, if I'm the Canadian company in the US, I need you to absorb some of this cost. You're gonna have to, you can't charge me $100 for the handbag anymore because I just simply can't, I can't absorb all those costs on my own and I can't pass them on to a consumer. And, if you can't help me out here, I'm going to buy Canadian made handbags instead. Um, or as if the answer from the vendor is no, I'm not prepared to do that, then as the Canadian importer, I might say, well, you know what, I'm going to go and see if I can get the handbags from Europe instead because I don't have to pay any duty on the handbags from Europe. So switching to the next slide. So we've heard a lot about a lot of tariffs, and it's super difficult to keep track. Bottom line, there is many tariffs that have potentially been announced by the US administration on products that are sold from Canada to the United States and imported into the United States. So we do have one now that is currently in effect. So on yesterday, the 25% tariff went into effect on all products of Mexico and Canada that come into the United States, except for energy, which is subject to a 10% tariff, presumably because the US does have a certain level of dependency on our energy, so they don't want to make their importers of energy pay 25% more, for example, for crude oil. There was also an earlier additional tariff on China origin goods. Those tariffs can affect Canadian companies too, because oftentimes, if you're a Canadian company, you're sourcing from a bunch of different places in the world, one of which might be China, and then you might distribute to the United States. So the fact that it's coming from Canada is not going to get you out of having to pay that or having to have the tariff imposed when that product goes to the United States. You may not be the one that pays because it's probably your US customer that actually pays. On March 12th, the United States has announced that there will be a 25% tariff on steel and aluminum products and also certain products that contain steel and aluminum. And that will be from everywhere. So anywhere in the world. So obviously the price of steel and aluminum in the United States is going to go up dramatically unless they are able to obtain that steel and aluminum from domestic suppliers in the United States. April 1st, the US has announced that they're looking at and will issue a report relating to reciprocal tariffs. So this is, if India charges a 10% tariff on a certain widget when it's imported from the United States, then the United States says we're going to charge a 10% tariff on India when we import that widget from India. So that's kind of the concept of a reciprocal tariff. And also, there may be additional sectoral tariffs on certain products that they've announced, like pharmaceuticals and a list of products considered to be strategic from the United States perspective. Semiconductors, lumber. And the important thing to realize is that all those tariffs, as currently contemplated, could layer on top of each other. So keep in mind there's already a 25% tariff, for example, on lumber that comes from Canada. If there's an additional tariff on lumber, lumber could be tariffed at a 50% rate. And again, this is for the most part, US companies that will be paying the tariff, and that those monies will flow into the US government. So turning to the next slide. So what has Canada done in response? Many of you will have heard of Canada's retaliatory tariffs. As soon as the United States put in effect the 25% tariff against Canada, our government took action to retaliate by imposing a 25% tariff initially on a list of $30 billion worth of imported US origin products. So now our companies, when they're importing those products from the United States, will have to pay a 25% tariff on those products. The way this works is that every product that's imported into Canada has a classification or a tariff code associated with it. And so that order imposing the tariff lists all the tariff codes to which the 25% tariff will be applied. Because right now, Canada hasn't gone whole hog. It's not all of our trade with the US that is tariffed. It's just this initial $30 billion list. The government of Canada has also already issued an additional list of 125 billion US origin products. And that's open for consultation for a 21-day period, but then that list will go into effect as well. So basically, within 21 days from now, if nothing changes, which a lot could change, but if nothing changes, we will have tariffs against 155 billion dollars worth of products that come from the US, which is very substantial because our overall, it's about a third of the value of what we import from the United States. And other retaliatory measures are on the table as well. Many of you will have been reading media reports of, for example, LCBO, Doug Ford taking alcohol that's U.S. origin off the LCBO shelves, certain government procurement measures. So just a real economic change in many different areas. And again, we just don't know at this point in time how long this incredibly disruptive situation will last. So turning to the next page, impact on business. I'm not going to go through all of this. I'm just going to leave this for you. But essentially, tariffs have an inflationary effect because the cost of goods go up. So that is obviously difficult for our economy and diminishes the purchasing power of Canadians. And it just has a contracting effect on the economy as well, because Canadian businesses who import have to pay more money for what they import. So, so then the sales of their products become more expensive and less competitive in global markets. And our Canadian businesses potentially lose a market in the United States because they're not as competitive in that market due to the tariffs. So it's both inflationary and also contracting from an economic perspective. I'll turn to the next slide. And I've already gone through those macro effects. What I just wanted to point out here is I'm not an economist. This isn't me speaking. This is from the impact on GDP and the impact on inflation that's cited on the next slide over. This is from a Bank of Canada report on the impact of tariffs that was issued in January. And if you're looking for, solid predictions, economic predictions of what impact lasting tariffs would have on the US or on the Canadian economy, that report is there, and it's very sobering. So I'm going to stop there so we can turn it over to the employment part of the session, and I'll turn it over to Chris. On that happy note, I'll turn it over to Chris.
Thanks, Wendy. That was a rather ominous finish, but yes, it is going to be very disruptive and difficult. Thank you, everyone, for coming. We always know this is a big chunk out of your day, particularly over your hopefully your lunch break, maybe some other times. But we really appreciate you taking the time to join us and to learn a little bit. The goal of this, my part of the presentation, is really to help employers make informed decisions. Not easier decisions, but informed, well-informed decisions. And what we're trying to do is make sure that we learn from the COVID experience, if I can say it that way. I can't see the slides. Am I just on the wrong screen? Hang on. And so I'll just keep going. We'll get that sorted. So learn from the COVID experience. During COVID, the early days of COVID, and you try not to remember, but it's difficult. Snap decisions were made by many businesses Those decisions made a lot of sense to the businesses at the time. It was unprecedented times and they were making quick decisions. But what happened really was it created unanticipated legal issues as time went on. And so what we're trying to do is people didn't realize the liability that they were incurring as a result. And so that only became known after the fact. And unfortunately, in many cases, it was too late to reverse the decisions that had been made. And so what we're trying to do is make sure that when you're making those decisions, you are making them in an informed manner. So my presentation is going to focus on primarily non-unionized, provincially regulated employers in Ontario. That's where I practice. Those are who my clients generally are. Many of the comments that I'm going to make, particularly around layoffs and that sort of thing, will not apply to a unionized workforce. And that's because they have collective agreements and they have termination and layoff provisions in those agreements that will govern those relationships. But many of the comments that I will make relate to federally regulated workers. They relate to workers outside of Ontario. And so please don't disconnect because you don't have as many folks in Ontario or you're watching this from somewhere else. The goal is to take back, my goal is to have you take back to decision makers clear advice on options, risks, and how to execute. And so the starting point for this discussion is whether the employer has the right to do what makes sense, which is to make those quick decisions that are going to cause or potentially cause incurring those circumstances. Are we sorted on the slides? Because I'm having difficulty seeing them. So what I'll do is the slide I want to see now is has the employer's legal rights. During COVID, there were reactions to preserve cash, reduce costs. One of the bigger costs is the workforce. And so consequently, they were making adjustments to the workforce that were causing businesses to have potential liabilities. Many of those decisions during COVID were imposed by government shutdowns, but not all of them. Many decisions were made by businesses who were allowed to continue to operate, but they were suffering a business decline because of the overall impacts of COVID. That is the closer example here. So we're not talking about the restaurants that were closed. We're talking about the businesses that saw their volume of business reduce, and consequently, they were not able to continue to operate in the normal course. They made a lot of assumptions. And most of the time, they were making those assumptions without professional advice. And so the kinds of decisions that we saw businesses make were they were implementing temporary layoffs. They were doing across-the-board compensation reductions. They were imposing the use of accrued vacation time so that employees could receive their pay, but it was reducing their vacation bank. So made with the best of intentions. We saw examples of businesses consolidating their workforce in a different location while you're causing people to travel a different distance. We saw remote work imposed to avoid real estate expenses associated with operating the business. In some cases, we saw businesses eliminating the tools that were used to perform the job, which made it different, but in many cases more difficult for employees to perform their functions. And so in those circumstances, you have potential risk. It can create liability. And so the starting point for the discussion is the employment relationship is a contract. You enter into contracts every day. When you buy your coffee or your other your groceries, etc., that's a contract. It's a different kind of contract, but it's a contract. The employment contract can be written or unwritten in a non-unionized context. And so the whole concept behind a contract is neither party can make a unilateral change to that contract. It doesn't, in the vast majority of cases, it doesn't matter why the employer is making the change. The common sense, they would say, of making that change doesn't matter. The fact is you're making a decision that has an impact on the employee. There are lots of cases, and these are not new. These are not related only to COVID. They were long before COVID. And they say that a business downturn is not a justification for imposing unilateral changes. And so it is very important that employers recognize that, generally speaking, they do not have the unilateral right to make changes, even for good reasons. And so what are the terms of the contract of employment? That's the question that needs to be asked. So I'm going to talk about constructive dismissal. So constructive dismissal is, as defined by the Supreme Court of Canada, a unilateral and substantial change to a fundamental term of the contract of employment. That's in a nutshell. And when the employer makes that change, that is a breach of the contract. And so what is the consequence of that breach? So to think of it another way in terms of a constructive dismissal, every job has a bundle of rights and obligations. You're going to do this job. You're going to do it as I ask you to do it. I'm going to pay you this much to do the job, etc. Those are the bundle of rights and obligations. Another way of thinking of constructive dismissal is I am terminating you from that job that has that bundle of rights and obligations, and I'm offering you a different job, similar, presumably, but not the same, with a different bundle of rights and obligations. And so when you think of it that way, it I hope will make more sense, because at that point, when the employee is offered that different job, they have the right to make an election. Do they want to accept the job, accept the change, and stay in their employment with the employer, or do they want to reject the change? If they choose to reject the change, the way that they respond to that is they resign from their employment. They treat themselves as being terminated from the job, and then they go about enforcing their termination rights. So to the employer, it is the same liability in a constructive dismissal as if the employment had been expressly terminated, as if you had walked into the employee and said, I'm terminating your employment, as opposed to I'm making these unilateral changes. Well, what is the consequence of that? Well, for some employees, it's up to 24 months total compensation. That is the potential liability. And so when you do that math with one employee, that's a substantial impact. If you do that math across a group of your employees, because you are imposing changes on more than one employee in the context of your adjustments to the effective tariffs, that's when it really becomes potentially catastrophic. And it's an unintended result. You didn't, generally speaking, make the decision to terminate. We'll talk a little bit later in the presentation about making the deliberate decision to terminate and what the consequences are. This is, I would suggest, worse because it's unintended. You didn't plan to terminate. You didn't plan to incur that liability, and so you haven't been able to plan for it as you otherwise might. The next slide, please. So, and again, I'm having trouble seeing it, so I'm hoping it starts with strategies. The kinds of strategies that we saw, again, are proactive reduction in hours and wages. So if you're an hourly paid employee, you reduce the hours, you reduce the wages. For salaried employees, you see we saw reductions in salaries. Now, what many employers did was they implemented the kinds of changes that I'm referring to, they did it across the board. They did it across their entire workforce. And in many cases, what they did was, for those that were at the lower hierarchies within the organization, it was and I'm just picking these numbers, but this was sort of not uncommon, a 10% reduction for the people sort of at the lowest level of the hierarchy, 20% for people in the middle hierarchy, and 30% for the people at the highest part of the hierarchy. And so the sense was, we're making the change with everybody. We are making the sting more acute to those at the higher echelons of the organization. That's all fair. That all makes sense. There can be no doubt that that is a reasonable response. What many employers also said was, we know that others in our industry are doing the same thing. So we feel like we are reacting in a way that is consistent with the industry. And so how can that be a problem? Well, my reply to that typically is a bit of an analogy, and that is, and I live in Southern Ontario, and so everybody speeds on the 401, but that doesn't make it legal. And so if you are the person who is pulled over by the officer and your excuse is, well, I was keeping up with traffic, that is not going to avoid the ticket. And so the argument that I'm doing what everybody else is doing, I'm doing it across the board, I'm doing it in a way that is proportional given the earnings and the roles that each person has within the organization, that doesn't change the fact that from a legal perspective, you are quite likely engaging in a constructive dismissal. The thing you always have to remember, and again, in a non-unionized context, the relationship is an individual relationship between the employer and the employee. So it is the impact on that individual that will be analyzed from a legal perspective. So the and where the employee accepts the change, that doesn't create a right. That simply means that the employee has not elected to take the position of constructive dismissal. So we shouldn't get too comfortable that if we impose the kinds of changes that we're talking about, that and we don't get an immediate reaction that we're sort of safe or we're otherwise not at risk. We may remain at risk. Another strategy is temporary layoffs. And I wrote a separate article on the issue of layoffs because this was one of the most immediate reactions that employers imposed. And so I'm going to start with what's a layoff. And the reason I start there is because there is a misuse of that phrase in the popular media and when in the sort of the vernacular. The definition of a layoff is it is a temporary cessation of the working relationship. So you send the employee home, they no longer have to provide service, but you're no longer paying them. There is an intention that that will be temporary and that you will recall the employee at some point in the future. In the US, if you're familiar with the US or you have operations in the US or you're watching this from the US, the phrase that I understood was used there often was furlough. So it's a temporary interruption in the relationship. Contrast that with a termination, which is a permanent end to the relationship. So when you're reading the newspaper headlines that say, layoffs at such and such a business, most of the time what they really mean is terminations at that business. Layoffs are intended to be temporary. Now, we talked a moment ago about changes in compensation. Well, this is sort of the most dramatic change of compensation. Rather than a 10% or 20% or 30% reduction, this is a 100% reduction. You're sending the employee home and you're not paying them anything. And so it has obviously a very dramatic effect on their terms of employment. The second piece that I want you to take away from this discussion on layoffs is there is no automatic right to lay off employees. There is no automatic right to lay off employees. There are lots of cases in Ontario and in other provinces that confirm that there is no right to lay off unless the employer and the employee have agreed that the employer has that right. And so you will ask, of course, as a follow-up, well, the Employment Standards Act has in Ontario and similar sort of applicable legislation in the other provinces talks all about layoffs, has all sorts of provisions that talk about layoffs in them. The case law says that doesn't create the right to lay off. That governs the rules related to the layoff. So in Ontario, for example, the layoff cannot be for more than 13 weeks in a 20-week period, or if certain requirements are met, 35 weeks in a 52-week period, but it doesn't create the right to lay off. And that's where many of the employers made mistakes in COVID, and not just in COVID, more recently, in circumstances where they had suffered a reduction in business and imposed layoffs. So it requires a contractual right to lay off, and I'll talk a little bit more about that in a few minutes. And so what is the consequence? Well, it's a constructive dismissal. You have failed to provide the work and pay the wages that you had contracted to, and so it's a breach. I'll talk a little bit more about sort of how to determine whether it's a constructive dismissal in a minute. Other strategies include the use of the work share program. That got some heavy use during COVID. Generally speaking, in the normal course, it doesn't get a ton of use, but it is a program under the federal employment insurance legislation, and it is a way of trying to lessen the burden on employees who suffer a reduction in their hours of work per week. Now, it is disappointing, I'm going to say, that the fact that we have known that these tariffs were coming for at least a month. I think we thought that they were coming for more than a month, and yet there was no formal announcement yesterday. I'm not aware of a formal announcement today on how the federal government or even the provincial governments are going to support employees who suffer loss of work or hours because of the imposition of the tariffs. And so that is, as far as I know, TBD. But that program already exists. The government has sort of made noises that it is going to expand the availability, but exactly what that means is not yet clear. What the work share program requires is an agreement between the government, the employer, and the employees in a work group. So it is a formal agreement. The idea is the employees are going to be paid wages for the time that they work, and then they're going to collect EI for the time that they are not working. And that EI will not be subject to a clawback as it normally would, because the employee has some earnings during that same week. That's the idea of work share. The requirements to participate in the work share program are a temporary decrease in business. Let's hope that this is temporary. Beyond the employer's control, I think we can agree this is beyond the employer's control. The reduced work week is anywhere between 10 and 60%. Effectively, if you're a regular employee working a 5-day work week, half a day to 3 days a week. And the group of workers agree to share the work equally and accept the reduced work week. So you have to have a consensus and agreement among the employees in that working group to participate in the program. So when you're talking about an agreement among employees with the employer and the government, a program that is, needs to be submitted to the government and approved, and there's a bunch of information on their website about the process that they follow to approve it, we are not talking about something that can be implemented this week. I'm hopeful that, but not optimistic that it could be implemented this month. And so this is not the kind of immediate support that I think may be called for in what I think is a pretty dramatic circumstance that we're facing right now. Going back to sort of the outline of the program, it's a 26-week, generally speaking, not longer than 26 weeks, although it can be extended by 12 days, or 12 weeks, I'm sorry, if in certain circumstances. But again, the time is measured, the time for approval of the process is measured in weeks, not days or hours. And the worst part is if you informally implement this kind of a work sharing arrangement, but you don't yet have the government's agreement, any EI payments that are received during the period prior to the approval will be clawed back. And so it is not providing the kind of support that one would expect. The last thing I want to talk about is Supplementary Unemployment Benefits Program, which is SUB. Again, it's a situation where the employees receive payment from the employer and they collect EI sort of at the same time without a clawback. Think of the more common example is a pregnancy or parental leave top-up program. That's an example of the SUB. But in that case, you do not require the government's approval. You just need to satisfy the requirements. For a circumstance of the type we find ourselves in today, it does require government approval, at least at present. And so in that case, again, you're back to this is a program that is going to be implemented and be useful over a measure of weeks, not a measure of days or number of hours. So it's not going to provide the level of support that certainly some would have expected or hoped. It also requires a payment by the employer for no work. So the likely use of it is modest because employers are making these kind of changes to preserve cash. So the idea that they're going to pay for no work seems a bit unlikely. Next slide, please. So what you need to do as the employer is you need to assess the risk. So does the employer have the right to make the changes that they're proposing, whatever those changes are? And then you assess the risk of a constructive dismissal. So it's a bit of a decision tree. So the first point is there an express right in the employment agreement to impose the compensation reduction or the layoff, whatever it is that you're proposing? To determine that, not only do you need to have the words, whether that term is enforceable will be subject to the same kind of analysis that many of you are familiar with when it comes to analyzing the enforceability of employment agreements and termination provisions themselves. So was there consideration for the contract that was entered into? Does it comply with applicable legislation, the Employment Standards Act in Ontario? Is there any ambiguity in the language of that agreement? So subject to all of that analysis, if the answer is you have an express provision and you conclude that it is enforceable, there is no constructive dismissal. Because in that case, what you are doing as employer is you are exercising your right under the employment agreement to impose that compensation reduction or layoff. If the answer is no, you don't have that express provision, well then do you have a policy that says we have the right to lay off? Some of you would be familiar with the KVP test. And so, there's a number of questions that need to be asked. So is the policy inconsistent with an express term of employment? Well, it can't be much of a policy if it's contrary to an express term. Is the policy reasonable? Is it clear? Is it unequivocal? Was the policy communicated to the employee so that they understood it was a condition of employment? If you can satisfy that test, then the question is it a constructive dismissal? The answer is no, because you've got a policy. It's a term of employment as a result of the imposition of the policy. If the answer is no, you don't have a policy or you don't have a reliable policy, then you ask, is it an implied term of employment? Did this employee know that they were subject to a layoff? Had this employee been laid off in the past? Did this employee see other employees in a similar position to theirs laid off in the past at your workplace? Or are employees in similar positions in other employers in the industry? Are they aware that those people have been laid off? So those are kinds of the cascade of analysis that you want to use. If the answer is yes, the employee knew or should have known because they were aware of these circumstances, then it's not a constructive dismissal. But if they're not aware of those things or you can't prove it, and it's a very difficult thing to prove, then it likely is a constructive dismissal. And what's the consequence? We go back to that, the termination provision, or the termination rights. So up to 24 months. Next slide, please. So I want to talk about if you were implementing changes that may not be as dramatic as what I have been describing, maybe you don't get to constructive dismissal, because not all changes are constructive dismissal. Again, the test is a substantial change to a fundamental term. Well, how substantial is substantial? A layoff is substantial. A layoff is 100% reduction in pay. So I don't think that anyone could credibly argue it's not substantial. Is a 10% reduction in compensation constructive dismissal? There's this somewhat of an urban legend, I would say, out there that says as long as you don't reduce compensation by more than 10%, it's not a constructive dismissal. I'm not aware of any case law that has established that as a rule. There are certainly some references to that kind of a thought process, but I don't think you build your house on that. Because for several reasons, including, how is that measured, that 10%? Is it on each pay, or could you reduce their compensation by 25%, but only do it for 3 months? In which case, on an annual basis, it's less than 10%. How do you determine whether that 10% is met or exceeded or you've stayed below? It's, I think, much too uncertain. So I would encourage employers not to put too much reliance on that. Certainly, if you're going to reduce somebody's pay on this payroll compared to the last payroll by more than 10%, you certainly have reason to be concerned. So assuming that the change is not a constructive dismissal, or assuming that it is, but the employee does not choose to treat it as a constructive dismissal, what is their entitlement? They have a claim for damages. They have a claim for the amounts that should have been paid that were not paid. And so if that 10% or 20 or 30% reduction comes with no promise to sort of make up the pay when things get better, then it's quite likely that they're going to be able to satisfy the constructive dismissal argument, but you've also sort of said out loud what the potential liability is. So they have a claim for damages, or they can take the position of constructive dismissal, depending upon how serious the change is. What are the risks of claims? Well, most employees in our experience during COVID did not take the position of constructive dismissal, even though from a legal perspective, they probably had the right to do so. No existing employee is anxious, or most are not anxious to make a claim against their employer. And so many employees, despite probably having the legal right to do so, did not take the position that they had been constructively dismissed. They took the change, or they accepted the layoff, and then they hopefully were recalled, and things went on, and it was forgiven, for a lack of better way of putting it. But what we did see in terms of who was making those claims, the employees who were dissatisfied, that's who was making the claims. They didn't like the job already. They were upset by whatever circumstance. And they took the opportunity of the change to take the position that they had been constructively dismissed. And the employer was in a tough spot to create a response argument. Now, it's a pretty small group in our experience. I mean, if you think about it, during COVID, hundreds of thousands of workers were affected by changes in their working arrangements with their employers during COVID. There were only a handful of claims. And so one can expect a similar sort of response. Most employees are likely to accept it. But another group that we saw that were taking sort of the opportunity to take the position of constructive dismissal were older workers, particularly those with longer service, where they were in the latter part of their period of employment, their career, and they decided, you know what, I either don't want to go back to work or I'm afraid to go back to work in the COVID context. And so I'm going to take the position I was constructively dismissed. I'm going to make my claim. I'm going to negotiate a package, and I'm not going to return. Well, those, generally speaking, certainly if they're longer service, but if they're both older and longer service, those are the most expensive terminations, because those are the employees that are likely closer to that 24-month total compensation threshold. The other piece that you have to recognize is, and it's generally recognized by the courts, is older workers have a harder time finding replacement employment. And so even if you take the position that they could find replacement employment elsewhere, it's going to be difficult to prove that, because there's generally accepted that older workers are going to have difficulty. And so if you put together a few older, longer service workers or some dissatisfied workers, and they have entitlements of 24 months total compensation, or significant amounts of liability, you do the math on that. The 10% reduction that the employer was hoping to achieve has now turned into liability to one or more employees that is far greater than 10% of their total compensation. It's 200% of their total compensation that is owed, while not immediately in theory, it is certainly owed soon, and they will receive no value for the labor for having paid that amount. So it is an unexpected liability that can be utterly devastating to businesses if it's not managed well. Next slide, please. So to talk about terminations, if your business decides that it is going to implement terminations, here are the things that you need to be thinking about. There's the statutory notice entitlement, so you've got to comply with that. In Ontario, there's a statutory severance pay entitlement, so you need to comply with that if you're a federally regulated employer, also statutory severance pay. There may be mass termination provisions. I don't know the nature of the actions you'll take, but at least in Ontario, for example, if you terminate 50 or more employees at an establishment in a 4-week period, there is you've triggered the mass termination provisions in the Employment Standards Act. You owe a greater amount of notice to employees. You have obligations to communicate and provide information to the Ministry of Labor. So there are other additional obligations that you have. Another group that I want to talk about are fixed-term contracts. Those of you in Ontario are aware there's recent case law that says if you terminate a fixed-term employee and you do not have an enforceable early termination provision, you can be obligated to pay the employee the balance of the contract, and irrespective of whether they can or do mitigate some of their damages, it does not reduce the obligation of the employer to pay the balance of the contract. So as you are looking through your roster of employees and trying to determine who it is that you may have to have an impact on as a result of your reaction to the tariffs, be very careful about whether the fixed term contract employees that you think you can terminate without any more liability than set out in the contract. Please be diligent and seek advice on whether those termination provisions are enforceable. Because again, the unanticipated result of a termination can be that you owe the balance of the contract. And that is unplanned for. Another group that I want to talk about are temporary foreign workers. If you're going to impact those individuals, if you've got early termination provisions or you've got termination provisions in your employment agreement, then you're probably fine. But if you don't, then the notice of termination that those individuals would be entitled to at common law may be extended because they cannot mitigate their damages as easily. Typically, the working permit or the work permit that is issued to them to allow them to work is tied to the current employer, to you. And if you terminate them, they can only work if they can get the next employer to obtain a similar kind of work permit. That takes time, and it may not happen, or it may be difficult. So in order to address that, a court could impose a longer notice period. So again, as you're looking down your roster of people, bear in mind who we're dealing with. The last group is independent contractors. The question you always should ask yourself is, are they really independent contractors? And that will be determined not by what you call them or they call you or how they file their tax returns. It will be based upon the substance of the relationship. And that is something that your legal counsel can give you a much better sense of. And even if they are independent contractors, would they be considered a dependent contractor, which is sort of a category between employees and independent contractors? And the case law has developed where those individuals are probably entitled to the same amount of notice on termination as an employee would be entitled to. So again, as you're looking down your roster, those might be people you would look at first. Be careful. Make sure that you are making an informed decision. Next slide, please. So here are the takeaways. I wanted you to take back actionable information to the decision makers. I hope that you have received some of that. I want you to understand your rights and obligations and their rights, the employees' rights and obligations. Don't assume, verify. Another point that was made by one of my colleagues recently is communicate with employees. Explain where you are, what you're doing, why you're doing it, what's happening, what you plan to do, because most will accept the changes. And this could be an opportunity for you to really cement the relationships with those, despite the fact that it's a tough time. But without communication, you're letting them sort of fill the void of information, and it's probably not going to be favorable to you. So fill it with your own information. And then plan. Don't react. Plan. And then the last point is, and this is sort of a bit of an advertisement, but please get advice from professionals. Your accountants can help you, but your lawyers need to help you as well. And obviously, we would be happy to be those lawyers to help you. But it's really important that you go and get some professional advice and provide the necessary detail to those advisors so that they can give you the good and valuable advice. I know it's going to have a cost, but the cost will be outweighed by the value. Confident in that. So there, I'll stop.
Thank you, Chris. That's very good advice because these are very uncertain times, and we want to make sure that if we're going to move forward with any changes in our workplace, that we want to do that in a manner that would mitigate any potential risk and would be legally compliant. So I want to thank Chris and Wendy for this very informative webinar, and to echo Chris's comments again, if you have any questions, follow-up questions or more detailed questions, please feel free to reach out to either Wendy or Chris, or of course your legal advisor, if that's not Wendy or Chris. So thank everybody for joining us today. I hope everyone has a wonderful rest of the day. Thanks again.
Thanks for coming out, folks.
Bye, everyone.